What if I told you that $1 billion crime can cost less than a cup of coffee? Not in theory, not in metaphor, literally. In 2024, a global tech company with profits soaring into the billions settled a case with the SEC. Their penalty? $1. A fine so low it doesn't even cover the cost of printing the press release. But this isn't just about one company. It's about a silent mechanism, a game of optics, where justice isn't measured in consequence, but in perception. And the enforcer? The U.S. Securities and Exchange Commission, the agency meant to protect investors from deception, often plays both referee and stagehand in the theater of accountability. You're about to see how this happens, not in headlines, but in confidential settlements, redacted documents, and penalties that look more like favors. Because behind every record fine the media loves to echo, there are deals you were never meant to see. And once you notice the pattern, you can't unsee it. Today, we pull the thread on one of the most bizarre settlements in recent memory, where billions were made, truth was buried, and the punishment vanished. But to understand how the system allowed it, you need to follow the paper trail no one talks about. Because somewhere between a $37 million fine and a $1 disgorgement, there's a secret hiding in plain sight. On July 28, 2023, a financial document quietly entered the public record. It looked like any other SEC litigation release, dry, technical, designed to be unreadable to anyone without a legal team. But buried in the fifth paragraph, behind words like no admission of wrongdoing and voluntary cooperation, there it was, quote, disgorgement in the amount of $1, unquote. At first glance, you might think it's a typo, but it's not. It's deliberate. A formal statement written, reviewed, and published by the United States Securities and Exchange Commission, declaring that after years of investigating financial misconduct at Symbol Technologies, the firm would return exactly $1 to the people it allegedly deceived. Not a fine, not symbolic art, a legal conclusion. To understand the gravity of this move, you need to understand a word most investors have never even heard: disgorgement. Disgorgement is not a penalty. It's the amount of money a company is forced to surrender, not as punishment, but as repayment for illicit gains. It's supposed to restore what was wrongfully taken. In theory, it's the closest the system gets to justice. So why just $1? Symbol Technologies had just settled with the SEC for a seemingly serious $37 million. But a closer look reveals that most of that money isn't going to harmed investors. It goes into government coffers. The actual repayment, the part meant to undo the damage, was just $1. $1 for years of alleged manipulation, for misleading the market, for creating billions in shareholder value based on fiction. And this isn't a glitch in the system. It is the system. Let's rewind. In 2009, Bank of America was fined $33 million for concealing massive losses tied to the Merrill Lynch merger. Internal emails later surfaced proving executives knowingly withheld the information. The result? No criminal charges, no meaningful clawbacks. Another corporate wrist slap dressed up as justice. These aren't isolated missteps, they're a pattern. Look closely at these SEC cases and a strange rhythm appears. Big press releases, headline-grabbing fines, disgorgement amounts so small they'd barely cover a lunch tab, and deals that end the story before it begins. The public sees the fine, they move on. Shareholders shrug, stocks recover. Executives stay seated, sometimes even promoted. You might ask, how is this even allowed? Because the SEC isn't just an enforcer, it's a negotiator. And in the world of financial enforcement, everything is negotiable. Companies offer voluntary cooperation. They agree to settle without admitting or denying. And in return, the SEC drops deeper charges, avoids messy courtrooms, and wraps everything in a neat press release, just like the one you never heard about on July 28th. But let's not miss what's truly disturbing here. That single dollar isn't a mistake. It's a shield. A legal maneuver that allows a company to say, "We paid what we owed," without ever admitting what they did. It satisfies procedure. It empties no pockets. It rewrites no truth. It's accountability with the volume turned all the way down. And perhaps most chilling of all, this mechanism isn't even rare. There are dozens of cases where corporations walk away with their stock price intact, their executives untouched, and their reputations cleaner than the documents that expose them. Justice becomes a press release. Restitution becomes a footnote. And trust in the system? That gets quietly shredded $1 at a time. So before we move on, take a second. If this video has opened your eyes even slightly, tap that like button. It helps us spread what they're hoping no one notices. And trust me, what comes next? They really didn't want you to see. Because something happened just before that $1 deal was signed. And once you understand who was in the room and what was taken off the record, you'll never look at SEC settlements the same way again. Just days before the SEC announced its curious $1 disgorgement, something strange happened inside Symbol Technologies. A board meeting, off the record, no shareholders invited, no transcript released. But someone close to the room leaked part of the agenda, and what it revealed was revealing. The company's legal team wasn't preparing for a fight. They were finalizing a settlement script. Not a defense, not a confession, a script. Internal communications, reviewed in a confidential memo later cited in whistleblower filings, included lines like, "We believe this path minimizes reputational risk." Prioritize language that avoids implications of intent. $1 disgorgement signals closure without liability. Pause for a second. These weren't lawyers preparing to explain what went wrong. They were choreographing how not to say anything at all. It gets worse. 3 of the executives involved in those discussions, including the former chief compliance officer, had previous ties to the SEC. One was a former enforcement attorney. Another served as counsel in the Division of Trading and Markets. That revolving door? It wasn't just spinning. It was actively shaping the language of the settlement. Now, let's be clear, none of this is illegal. But when the same people who once enforced the law are now guiding companies around it, a question emerges. Is the SEC protecting the public or protecting their former colleagues? The strategic $1 disgorgement wasn't an oversight. It was part of a larger choreography, a dance between regulator and regulated, where the goal is to look responsible without being held responsible. And behind that, there's something else. Symbol Technologies wasn't just settling with the SEC. It was also preparing for a massive federal contract worth hundreds of millions of dollars, one that required, among other things, a clean record. A trial? Even an admission of guilt. It would have disqualified them instantly. But a neatly packaged settlement with no admission, no trial, and a symbolic $1 repayment. Perfect. Within 2 weeks of the SEC settlement going public, Symbol secured the contract. No delays, no controversy, just silence and a signed deal. Now let that sink in. A regulatory body designed to expose misconduct quietly clears a company's legal path just in time for it to land a lucrative federal agreement? Coincidence? Efficiency? Or something more orchestrated? And here's where you come in. If you're watching this from anywhere in the world, drop your city and country in the comments. Why? Because this isn't just an American story. It's a global system, where the illusion of justice travels farther than the enforcement itself. What country are you in? Do you trust your regulators? Or are you starting to see the same patterns? Because next, we trace a money trail that never should have existed and expose the loophole that let it pass through untouched. And once you see where the funds went, you'll realize the $1 fine was just the beginning. Follow the dollar. After the $37 million settlement with the SEC, Symbol Technologies was quick to reassure investors. Our business remains strong. No material impact expected. That line, it wasn't just PR. It was accurate. In the weeks following the settlement, Symbol's stock price barely flinched. Analyst ratings held steady. Investor calls used words like contained, well-managed, and non-event. But something strange was happening in the background. Buried inside the company's quarterly report, filed just 30 days after the SEC agreement, was a quiet line item labeled Regulatory Reserve Recovered. In other words, Symbol had already set aside money in advance to cover the settlement. The $37 million was accounted for long before the public even knew what had happened. But where did that money come from? Here's where it gets uncomfortable. Symbol had received over $110 million in federal subsidies, tax credits, and R&D grants in the previous fiscal year, a mix of incentives meant to boost innovation and job creation. And because the SEC settlement didn't qualify as a criminal offense, none of those funds were frozen or questioned. In fact, the company was able to reallocate portions of unused federal grant money to cover legal expenses. That's right. Taxpayer money helped fund the legal defense, which led to a $1 disgorgement, which paved the way for a new government contract. Read that again if you need to. But it doesn't stop there. One of Symbol's lead outside law firms on the case, a prestigious New York-based firm with deep SEC experience, billed over $19 million in legal fees. Guess what? That expense was tax-deductible. Not only was the cost of defending against investor deception absorbed, it became a business expense. The firm paid less tax, the company paid less tax, and the real cost? Diffused into the system. Even shareholders weren't particularly alarmed. Why? Because the company's stock buyback program continued, uninterrupted. In the 6 months following the settlement, Symbol repurchased over $85 million of its own shares, artificially propping up the price, reinforcing the illusion of control. Now pause. A company deceives investors, avoids trial, pays a $1 in restitution, uses government incentives to cover the process, then uses shareholder money to boost its own market image. This isn't just a legal loophole. It's a self-reinforcing loop, one that pays to fail. A loop where enforcement becomes predictable, settlements become cost centers, deception becomes manageable, and accountability becomes optional. And what happens when a system begins to reward silence over disclosure? You stop seeing warnings. You stop seeing whistleblowers. You stop seeing the truth until it's too late. But maybe the most disturbing twist is this. The person who approved that internal reserve for Symbol Technologies, the executive who signed off on reallocating government funds to legal coverage, he's now sitting on the board of another company under SEC investigation. Still active, still respected, still untouched. And here's the part no spreadsheet can capture. If one company can cycle through scandal this smoothly, how many more are running the same playbook? How many other settlements were prepaid, pre-negotiated, and pre-sanitized? How many times have you read a headline that was actually the end of the story, not the beginning? In the next chapter, we go there. Because while the system told us the case was closed, there's one thread they forgot to cut. One email, one name, one move that slipped through the script. And it changes everything. For weeks, the settlement remained sealed, controlled, clean, until someone made a mistake. An email, buried in a chain between Symbol Technologies' external counsel and an SEC liaison, was leaked to a journalist at a mid-tier financial blog. The article went unnoticed, fewer than 500 views. But one name in that email shouldn't have been there. It belonged to David Kessman, a senior risk executive at Symbol. Not a public face, not listed in the settlement. But the email revealed he had personally signed off on internal documents confirming that the company was aware of the misleading disclosures months before the investigation began. This was the moment. Because if Kessman knew, and the documents prove he knew, then the entire premise of no admission of wrongdoing collapses. But here's where the trail gets darker. Within days of that email surfacing, Kessman's LinkedIn profile was deactivated. His name was quietly removed from Symbol's internal directory, and when journalists contacted the company for clarification, they received a single-line response. Mr. Kessman no longer serves in any operational capacity at Symbol Technologies. No apology, no explanation, no mention of the leaked email. We searched SEC records. There was no amendment, no follow-up filing, no disciplinary action. He had simply vanished. So we kept digging. Turns out, Kessman was one of 3 executives who received executive performance bonuses tied to cost reduction during the settlement period. He earned nearly $2.1 million in bonuses while the company was negotiating how little it could pay back to investors. The logic? He helped minimize legal exposure and maintain operational continuity. Let that sink in. The man who authorized silence was rewarded for efficiency. And he wasn't alone. 2 of the law firms involved in the settlement went on to represent other clients under SEC scrutiny, using the exact same framework: settle early, avoid admission, isolate liability, and above all, control the narrative. But what no one accounted for was the email. A single digital footprint that cracked the illusion of a clean exit. And if that slipped through, what else is still hidden? Because if the system truly worked, if regulators were holding the line, if truth mattered more than appearances, then why is it that the people who bury the evidence keep getting promoted? Why are the fines symbolic, but the rewards are real? Why does the cost of lying feel cheaper than the cost of telling the truth? And maybe the most unsettling question, if a $1 penalty can clean a billion-dollar mess, what else can be bought for even less? They say justice is blind, but when the fine is $1, maybe it's just looking the other way. What you've seen isn't about one company or one regulator. It's about a pattern, a choreography, where accountability is staged, settlements are pre-negotiated, and the truth is buried beneath layers of legal language. And the most powerful part? It works because we stop asking questions. So let's change that. If this investigation opened your eyes, even a little, hit that like button. It tells the algorithm that this story matters. More importantly, it tells them we're watching. And if you want to see the next case before it disappears from the headlines, subscribe, because next time we're following the money through a different door. And what's behind it might be even darker than what we found today. Until then, Keep your eyes open and your dollar where you can see it.